was wanting to withdraw, and that motion was filed and the court denied it. And if he wants another attorney and does not want you to represent him, then he needs.
Welcome back to the courtroom, folks, and buckle up because this case is already off to a chaotic start. Right out of the gate, we've got a defendant who doesn't even want his current attorneys representing him anymore. He's been pushing for a new lawyer for months, filing motion after motion, but the court has made it clear, trial is happening, and it's happening tomorrow. Now here's where it gets interesting. The defense says they tried to withdraw because the client fired them, but the judge insists he hasn't asked for new counsel in this courtroom. Add in an absent lead attorney, a frustrated judge, and a defendant who insists he's not being heard, and what do you get? A legal powder keg about to explode. And if that weren't enough drama, the defense even objects to this hearing being live-streamed on YouTube, worried that potential jurors could be watching. But the judge, she's not having it. Objection. Overruled. So here's my question for you. If you were on trial for your freedom, would you stick with lawyers you don't trust, or roll the dice by going it alone at the last second? Think about it, because that decision could change everything. Let's dive in.
And we did not attempt to withdraw on our own request. We attempted to withdraw because he asked us to, and he's been asking the court to appoint him an attorney since July 2010.
No, he has not.
Those motions are in the file.
No, he has not been asking for this court to appoint him an attorney. And if my understanding is, one, you have not been the attorney who's been on this case. There's been another attorney from your firm. And where is that attorney? Because that's the attorney.
Resigned.
No, that attorney needs to be here because he's listed as his attorney.
Anthony Wilson, is that who you're speaking of?
No, I'm speaking
Carlos
of,
Ramirez?
yes, where is he?
I'm not sure. I think he is now taking care of other business.
He needs to come up here and take care of this business.
Okay. But Judge, I did see in Odyssey that there's been some pro se motions filed requesting an appointed attorney.
Let me just explain to everybody how pro se motions work. When somebody has retained counsel, their pretrial motions are not heard by the court.
Of course.
Their pretrial motions are only heard if they are pro se. He is not pro se. And Carlos Ramirez, who has been here, needs to be here. He knew that this was here.
Sure.
So I do not understand why he's not present.
Okay. But the issue that we need to determine is if he, just for the sake of trial, and I understand, Judge, that you're going to call this case tomorrow regardless, but for his sake and ours, I need to put on the record if he is wanting us to represent him at trial.
All right. So what I'm telling you is the person to be asked those questions and to put it on the record is Carlos Ramirez, not you.
Well, I am also listed as attorney of record, Judge.
Well, I'll have them check to see if that's the case. Ms. Ferguson, can you look and see if she's listed as an attorney of record? Or is it just their firm?
Judge, I see Carlos Ramirez, Stephanie Collins, Anthony Wilson, all listed as his
And are you Stephanie?
Yes.
All right, ask your questions.
Mr. Selinas Salgado, before this goes on, Judge, I would also object to this being broadcast on YouTube.
Damn. I'm sorry.
In the event that potential jurors are watching this right now, knowing that they're going to be called to this court tomorrow. I think that would be prejudicial, Judge.
All right, your objection is overruled. Do you have questions for him?
And I would object to the overrulement for the record. Mr. Selinas.
Just a moment. So this is how things work. You make your objections, I make a ruling. There is no, I object to the court's ruling. The court's ruling is the court's ruling. And if you're intending to preserve error, how you preserve error is you make a request, I make a ruling. That's your error. It's preserved. Preserving your error is not if I overrule an objection or I sustain an objection and you say, well, I'm objecting to your overruling or sustaining an objection. Legally, that's not how things work. So your objection to the broadcast is overruled. Now, here's my question. Is he going, if he were to be found guilty, is he going to the court for punishment or is he going to the jury for punishment?
We have filed a motion for jury, but I still need to determine if he wants us to represent him or not.
All right, so this is what I need you to do. I need you to listen to my questions, answer my questions, and we will go in the order that I'm giving you. So, Mr. Selinas, do you understand this process? Have they explained to you about jury trial? Well, let me strike that question. Don't answer that question. Let me explain to you. In this court, since you've been here, this is the process for this court. First thing that happens is I make sure that defense attorneys have all of the discovery. What is discovery? Discovery is items or evidence or proposed evidence about your case. So if there's a video that's about your case, the defense is entitled to have that. And I make sure that they have that. And if it's something that they say they don't have or something that they think they should have, and maybe the state has and hasn't turned it over to them, I'll make sure that they have that. So in your case, your attorney has said they have all of the discovery. So that means that all of the evidence that you're entitled to, they have that. Your attorney, Mr. Ramirez, has said that's the case. Then the next thing I do is I tell the state in this court that you have to tender an offer. That offer will be given to your attorney. That attorney will go over that offer with you. And then if there's something you don't understand about the offer, then you're to ask your counsel. Do you understand?
See.
Okay.
Yes.
So yes or no, has an offer been tendered to you in this case?
No.
All right, so this is what we're going to do. I'm going to have you sit down. The state will let this defense attorney know, because I know this defense attorney hasn't been here. It's been Carlos Ramirez. The state will let them know what the offer is. And then your attorney, who's here today, will let you know what the state's offer is. Then you will let me know whether or not you're accepting the state's offer or whether or not you wish to go to jury trial. Do you understand?
See.
Yes.
All right. All right. So first things first, Mr. Selinas, did you receive the offer from the state?
See.
Yes.
All right. Did you understand the offer?
See.
Yes.
All right. So knowing what the state's offer is, were you able to reach an agreement with them or no?
No.
All right. Are you asking for a jury trial?
See.
Yes.
All right.
And there it is, the moment of truth. After all the back and forth, objections, and heated exchanges, Mr. Selinas makes his choice. He rejects the state's offer and demands a jury trial. It's a risky move. Jury trials bring uncertainty, higher stakes, and longer battles, but they also put his fate in the hands of everyday citizens instead of a single judge. The judge, meanwhile, has kept a firm grip on the courtroom, reminding both sides that procedure matters, objections must follow the rules, and trial deadlines are not negotiable. This wasn't just about one man's case. It was a masterclass in how the justice system balances fairness, control, and the rights of the accused. So what do you think? Was the judge too strict, or was she simply upholding order in a case that's been dragging on for years? And would you have taken the deal, or gambled it all in front of a jury? If you found this courtroom drama as fascinating as we did, make sure to hit that like button, drop your thoughts in the comments, and subscribe for more jaw-dropping legal breakdowns. Because trust me, this trial is only just beginning.